Thank you very much, everyone, for being here today. Um, my name is Dia Uday, and I'll be the moderator for this session. We have a combination of great presenters today, as well as wonderful panelists who are here in person as well as online. Uh, I'll just set the context for the session really quickly, and then we can move to the presentations and the panel discussion. I just like to start by saying that, look, land can either serve as an essential asset for economic growth and to promote social equity, or it can be a tool with which to hijack economic independence or some amount of social processes. From an economics perspective, the question of land is largely linked to, agricultural productivity, agrarian relations, maybe even infrastructure development. From a social justice perspective or social equity perspective, it has a capacity to really shape the rubric by doing things like even simplifying or enhancing gender relations, for example. I think that finding a balance between the economics, and the socio-economic part of it is important. And one way to do that is for us to get a good understanding of what the challenges are, what the legal framework is like. Today, there are a lot of gaps in our understanding. We have a sense of some of the challenges from our perspectives. It may not be the whole of the perspectives out there. So what we have with us today is we have two presentations that will help us think about how we need to think about land reform or land reform 2.0, if you will, going forward. Can we think about how to map the frontiers towards a new set of land reforms for states, moving away from the old guard and moving towards something which is more current and perhaps which is more evidence-based? And then we go on to our panel discussion where we talk about just that, what land reforms in India today should look like, who should implement them, what should that balance look like, such that we have a great edge where there's more winners and less losers. So without much ado, I'm just going to hand over to our presenters. Arjun, can we just have you on and present to us the work that you've been doing? Please also briefly introduce yourself before you do your presentation. Thanks.
So hello everyone, my name is Arjun. I'm a public policy researcher. Currently I'm working with Prosperity. I've been working in the past with Center for Civil Society as well. Let me just pull up a slide deck. All right, so I want to make this presentation on mapping the frontier for land reform in India. This is an ongoing research project that has been going on for about 2.5 years. Still a long way to go, of course. It's a slightly long presentation, so I might race through some parts, but I'm here after if you want to talk about some of the parts that I didn't cover here. So Um, um, there's no Great. Thanks. All what we find in the land law universe is that the existing land laws have undermined the main objectives for land reform, which were increasing productivity, improving equity, and increasing the tenure or security of tenurial farmers, right? And so post-independence, the land reform shifted from the sort of clearing the welter of rights, where you have overlapping claims, towards state-led land redistribution, land use, and transfer restrictions. But what this has done is worsen the problem of land fragmentation and increase the cost of land consolidation. So it has increased the burden of land acquisition laws and the state to bundle these land rights for both public and private projects. And subsequently, the removal of property as a fundamental right from the Constitution, along with the ninth schedule, protect current laws against judicial scrutiny, have made this more persistent and endemic problem that is very difficult to fix. And so this is the context from which we're operating. In 1955, 78% of rural households were landowners. In the 2019 NSO data shows 97% of agrarian households were landholders. Now, of course, it's a sharp improvement in the percentage of people who hold land, but the size of the land owned has significantly shrunk from 0.4 hectares per family in 55 to 0.5 hectares now. And at these sort of sizes, productivity gains are difficult to find, mechanization is difficult to use, and you're sort of stuck in this very low farm size equilibrium. And over time, also the number of medium and large land holdings has predictably as well fallen all the way down to 2% in 2019. And it's important to note, you enter medium at 4 hectares, which is not a particularly large land size when you're talking about uh, significant gains from agricultural trade, right? So, what has this? What are the consequences of this old land reform approach? Only around 2% of the cultivatable area nationwide ended up being redistributed. Actually, there was large-scale falsification of land records and fragmentation, both of land titles and land claims, and large-scale expulsions of tenants from zamindari land before any of the redistribution happened. And in fact, one of the key motivators was to improve security of tenure. But in fact, this worsened under the new tenancy regime because most landowner-tenant arrangements took very informal routes. So the biggest problem right now we're trying to think about is how to address land fragmentation, right? So the entire set of post-independence land reform laws have shifted this burden of bundling to the state's eminent domain powers. And literature has increasingly come to recognize the link between land ceiling laws and fragmentation. And this problem of land consolidation is further hampered by restrictions on leasing. One way to consolidate land is by mass purchase, but that same consolidation can happen through leasing as well. And this is particularly stark because 46% of India's workforce is dependent on agriculture, but they contribute only 18% of GDP. Now, if we're serious about increasing farmers' income, we do need to think about how many farmers can the agrarian land available truly support. So bridging the gap. So what shapes our approach, right? Decentralization of land in India makes it highly local, and an overarching solution cannot work. There's a lot of heterogeneity from state to state, from within regions in the same state as well. And transplantation of policies from other countries is unlikely to work. So we need a first principles based on the context approach. Technological, including digital solutions, require fundamental reforms. Otherwise, you're just essentially digitizing the problems that currently exist. And while it may solve some issues, a lot of issues actually might get just solidified in that digitized framework that make even informal negotiations impossible. So what do? We started by reviewing laws from a sample of states to identify some components and themes to help us better answer these questions. We identified relevant laws, read through them in detail, and categorized provisions affecting tenure, transactions, and land classes. And we slowly expanded this to cover all the states and modifying the categorization as necessary with some unique characteristics of some states which were not in our sample set. One reason this is different from past approaches is a lot of the academic literature comparing states on land reform have adopted a count methodology. We just counted the number of land reform laws that exist instead of looking in detail at provisions in each state. Largely perhaps because this research effort has been led by economists and not so much by the legal fraternity. So here are some themes that we identified. One is the recognition of tenures. So these are leasing agreements, and here are some examples in which this is restricted. No leasehold tenure can be created except by a soldier or a seaman in Karnataka. Or in Himachal Pradesh, no leasehold tenure can be created except to a person cultivating a contiguous land. Sorry. Similarly, there are restrictions on the exercise of rights, restrictions on use. For instance, a permission for land use change, or that land cannot be transferred for any other purpose until 10 years from the date of transfer. So these constrain the ways that the landowner can use their land. Then there's also restrictions on transfer. A whole host of restrictions across all states exist which prevent the sale of land to a person of my choosing. For instance, in Class A irrigated land, any transfer is prohibited. There's also restrictions on who you can sell to if you've had a tenant in the past. If at some point of time I leased out my land, my tenant now gets the right of first refusal. You know, a few years down the line, I might, after leasing, want to sell out agricultural land, but my tenant gets the right of first refusal. There are also restrictions on contract terms, rent ceiling laws being one of the most straightforward examples. And there's also the costs of exercising these rights. These are procedural costs and monetary costs imposed by the law for you to exercise the rights that on your land. So I'll just quickly, so components of rights. And then this is an example for agricultural land specifically. We're not looking at non-agricultural land now. So what we did first is break it down into subcomponents. So if you look at A1, A2, A3, they look at restrictions on the purchase and holding of land. On top of that, if you look at the B1 through 4, there are restrictions on how you lease your land. First question, of course, is, am I allowed to lease my land at all? If I am, what sort of conditions exist? Am I allowed to lease it at any rate I choose? Is there restrictions on how long my contract is? And so on. And B4 is right to preserve and resume ownership. Multiple states have provisions which say that, yes, you can lease your land, but once you take your land back, 50% of that land must remain with the tenant. So this sort of creates an, I didn't mean to go ahead. We also go, C1 is the right to use land. This is like, for instance, the right to change land use. Right to mortgage land. How easy is it for me to mortgage land? What are the market dynamics there? And what is the security in property in land? You know, how extensive are the state's eminent domain powers to acquire my land? And finally, we have a clarity in legal claims to property. This sort of captures of all the exceptions that exist, right? And I'll walk you through an example in a minute or two to show you that. So our index, what we're trying to measure is the rights and restrictions that exist at various levels, at the transaction level, at the tenure level, at the land classification level, and the state level. This is designed to give us a nuanced and accurate understanding of the existing state of land rights across Indian states. And I'll walk you through one example of land leasing particularly. So this is just looking at the B1 through B4 components that I gone through here. Our normative stance that we're approaching is freedom to contract and ownership rights should allow land leasing. The functional reason for this is restrictions lead to informal markets. And if you look at this, this sort of captures the gap between the formal and informal market. And there's a humongous difference, right? And what are the downsides of the informal market? I will go through that. And we have a small survey if I get time to do that. So what is our ideal state? Our ideal state is when there's a respect for contract and autonomy. This is also based on the NITI Aayog 2016. They put out the Model Agricultural Land Leasing Law. And this is sort of the framework that they approach leasing rights, where you have a right to lease, where the sublease is with the consent of the owner, rent is determined by contract, and you have a right to complete resumption of your land. And so we looked at all these components and then scored them from a 0, which is ideal, to 1, which is the most restrictive. Let me just quickly walk through some provisions. Maharashtra has adopted a law which essentially copies almost all aspects of the Model Agricultural Land Act that was enacted in June 2023. So if you see Maharashtra scores and the Model Act scores will line up almost exactly. But as you can see, there's a huge amount of variation. Karnataka, for instance, only allows soldiers and seamen to lease their land. This talks about what sort of restrictions exist on types of contracts. Am I only allowed a sharecropping? Do I have minimum or maximum terms of lease? Some states require that the term of lease be between 3 to 6 years, or a minimum of 11 months, or a maximum of 11 months. There's a large amount of variation across states. Similarly for rent controls, and I'm just going to run through this quickly because of time constraints. So some survey results. This survey was done before the 2023 law change. We did a semi-structured interview with 120 respondents in 4 districts. What we found that only 5 out of the 114 farmers had a written contract. 4 of the written contracts were essentially written out in a small piece of paper. There was only 1 formal lease, and that was land leased out by the temple trust in a particular village. Of the 114 agreements, 111 had long-standing relationships. They were neighbors, they were in-laws, they were related in some way. However, in spite of all of that, most tenants did not receive crop insurance at all. That went straight to the landlord, even though quite often the rent agreement was a full cash. So it was not like the landowner was bearing any of the cost of production. But the insurance still went only to the landowner. Tenants were predominantly landowning. Agreements were always under a year. And And this last point was that the rates that were paid for agricultural land varied greatly within the same village for comparable land. This is probably because price discovery becomes very weak in a market which is fully informal and where the formal market mechanism cannot kick in. And yeah, I'll just kind
of. Thanks, Arjun. We'll just have Manoranjan, please go on. Do you have a presentation? Yeah, please go ahead and set up. Thanks, Arjun. That's an interesting presentation. Thanks. Just give us a sec while Manoranjan presents.
This is Manoranjan Sohi. I hail from Jagatsinghpur district of Odisha. I'm an individual, independent researcher along with a lawyer. So, okay, thank you. So, welcome to the today's presentation. I'm going to present land tenure and alienation in tribal Kalahandi, a participatory applied legal research. This is called Kandulguda village, one of the border village of district Kalahandi and Raigada, Odisha. The village is more closer to block Kalyan Singhpur district Raigada. So the villagers solely depend upon the Raigada district. However, the village is coming under Kalahandi district. So the village has 30 households. Out of it, 29 are Kon tribal, which is Kon community. It's called tribal people, and one community is Dome. It is scheduled caste. So the villagers, because of the border village, the villagers have been deprived from many of the developmental initiatives. But the villagers are happy with that, and they never complain about it until April 2023, when an outsider named Dilip Rao, son of Manik Rao, he's a Sahukar, entered to the village and threatened to the villager to not using the land because the land belongs to him. And after that, he brought revenue inspector with him and demarcated the land. And revenue inspector also threatened to the villagers to not use the land. So after that, the villagers stopped using the land. So these are my three objectives. First one, to explore the land tenure system in tribal village. Second one is to understand the impact of land alienation in the village. And the third one is to understand local administration's role and how the villagers and use the technology while this land has been alienated from them. So for that, I use mixed methodology. In secondary research, I explore legal and constitutional guarantee and the international guarantee for indigenous people, alongside case laws and judgment passed by the Indian courts. And in primary research, I use participatory observation, survey, interviews, and documentary evidence. So these are the findings. So first one is very interesting. I mean, the relationship between Kon and Dome and tribal and the scheduled caste is very conflicting relationship, because the Dome community, like scheduled caste community, doesn't own any land, and they're always looking for buying the land because they have the resource. So and in Kandulguda village, because this is the main reason behind this land alienation. And the second point is says survey. I mean, in this during the survey, I found, because of the land alienation, it has affected various. It affected various aspect of the community life, like socially, economically, religiously, and medical also. And in key interviews, it's a very interesting thing. The relationship between land and the tribal is very crucial and very important. It's interesting. So that they never look at the land as an asset. Rather, they believe land is the second mother, and also it is the essence of their life. But tribal people, they never sold the land just because the sake of the money. So the documentary evidence revealed land belongs to Dilip Rao, son of Manik Rao Sahukar. But the question raises here, how come it's possible in the middle of the tribal land, a non-tribal land occupied a very big portion of land, and also it is a scheduled area. So the Sahukar belongs to Andhra Pradesh, but he's settled down in Raigada. So in Sahukar means there is a community who have the resource, who have the money, and whenever the villagers required money, they used to take the money as a loan. So the interest of the loan is, if the tribal person takes 1,000 rupees, then he has to pay 250 rupees as an interest every year. So the village meeting helped to understand the inaction. I mean, why the villagers did not take any action, and also the village meeting helped the villagers to raise their voice. So due to destruction, Debistal, actually, when the land has been inherited from the community, the Sahukar destroyed the land along with Debistals, 3 different Debistals, and that because of destruction of Debistal, 3 deaths occurred in the village. Then it is also the link. I mean, there were 3 young youth migrated to the Vijayawada city in search of work. The name is Babu Maji, Lakhan Maji, and Bhima Maji. And because of this land alienation, it has affected to their family also. Actually, the people have been using the land since the time immemorial. Once they stop the cultivation, then there is no other work. So they stayed in the male person started taking alcohol, and that leads to disturbances. And there are students called Arjun Maji who dropped out from the school after 5th class because due to constraints of money, and it also affected their mental health also. While I was in the community, I one day the solar motor was stolen by some people. Then the villagers could not complain it because they believed, they considered this has happened because of we are raising our voice against the Sahukar. And that is the only water pump in the village. After the motor is gone, then the villagers use the river to drink the water. So, so the village actually, due to no internet connectivity, the villages are isolated from the outer world, and also this is the main reason for the outsider or for the elite caste who are dominating on the community. So, aspect of the study before my intervention, the villagers, they are very fear. I mean, वो बहुत डरते थे लोगों से, पुलिस के साथ या फिर लोकल एडमिनिस्ट्रेशन से बात करने के लिए. बट आफ्टर माय इंटरवेंशन दे स्टार्टेड एंगेजिंग विद द local administration, like more than 2 times people visited to RI office, revenue office to apply the EC, incumbrance certificate, which can help the villagers to know how the Sahukar on this land. And they also reduce the dependency on Sahukar. Since I told you, Sahukar is the person who has the money and who has the power also. So this Kandulgula village, they used to take the money from the Sahukar, that particular person, and also they used to sell their production to the person who alienated from the people. And after the intervention, they have started reducing the dependency. And the Nokuraik, actually, I already told you, one household, who is Dom household, and the Nokulak is the head of the house. So Nokulak is a contractor. He used to he used to give the work to people, and his mother used to sell alcohol to the people. So indirectly, this household control over whole community, and he is the main person who is behind this land alienation. Personal transformation. There are few person like Guru Maji who quit the alcohol, because after the land alienation, people have started taking alcohol. So after the intervention, there are some people who alcohol. This then awareness of legal rights. Actually, I use simulation-based model to make aware to the people. So this helps the people to understand their rights and to raise their voice. So improve community solidarity. Actually, in that village, there were before my intervention, there was one person who used to take the decision. It's called Ghantia. I mean, village head. His name is Mukta Maji. But after the intervention, they are collaboratively taking the decisions and collaborating and grouping in the village and raising their voice. Then it also strengthen the community, and before my intervention, there was only one leader who used to take the decision, who used to lead the community. But now there are more than 3 people evolved during the process. Before my intervention, there were 9 households who have the ROR, record of the rights, but now another 11 people added in that list. But however, they don't have the physical hard copy of ROR. But in Bhulek Odisha, it's a proof of that they have the land. One interesting thing is, 20 people have the ROR. It means a record of the rights they have, but there is no land. They don't know what is the land. So this is the Antiquity of Land Ownership. Historical record says traditionally the land has been transferred to male. I mean, there is no female who owned the land. Oral testimony says the village existed more than 100 years. Oral testimonies of the in the Kandura village. Along with that, I visited to neighboring villages. Archaeological studies confirm that more than 6 generations the villagers have been staying in that village. So these are the collaborative project. Actually, it's very important to understand the nexus between private elite entities and the elite entities and petty land administration. And Kandulguda is the perfect example of it. It is very important to digitalize portal, and it has to be accessible for the people, for those who it made. And also, land is protected until it is hand in the tribals. In Kandulga case also, once land has been alienated from the people, the land is bare. I mean, though nobody is using that land. So that is another lead to climate change, and also the community becomes more vulnerable and marginalized. So role of researcher and practitioner, it's very important because in this issues like NGOs more they don't involve the land issue because they believe it is against the state. But this is not sometimes the individual entities also occupied the land. Last one, it is the land ownership should be clear and the technology should be user friendly because in Kanduluguda village, there are so many villages who doesn't access the internet. So it's very important whenever we formulate any policy or law, it's very important to look keep it out in mind. So sorry. So way forward, as a lawyer, I observe we have so many laws, so many policies, but the biggest problem is the language. All of it in in English or Hindi languages. So it's very difficult, it's almost impossible for the tribal people to access it. And simulation-based model is, I believe it is a very interesting model for the people, for the villagers, because while I was staying in the country, I used the same model and it's helped to the villagers to understand their rights. Interdisciplinary approach, let me share with you a very interesting story. When I finished my LLB, I felt very empowered. I thought, okay, अभी तो मैं गाँव जाके कर सकता हूँ. तो जहाँ पे मैंने जब काम शुरू किया गाँव में तो मैं रियलाइज किया it's not one man army. So you need support. You need support. So and the second and the last one is story and interaction based. Whenever we are engaging with the community, we must remember the story and interaction based. So when we are aware this, these are some photos. This is land before intervention, and this is the land after intervention. But the problem is not solved here. We need support. I need support to continue this work. Thank you so much.
Thanks, Manoranjan, for that. I think our presenters have given us a diverse set of perspectives with which to think about land reform. So I just want to begin with the panel discussion. We have with us Dr. Mautoshi, who is an assistant professor of Faculty of Law, University of Delhi. He's also Deputy Dean Legal Affairs of the University of Delhi. Do you think there's a need for land reforms, or are we overstating the problem?
Thank you. Yeah. So when we talk about land reforms, am I audible, everyone? Or can I speak without a microphone? Okay. So when we speak about land reforms, we need to first decolonize the land tenure system. In India, we have been inspired by the colonial system of land tenure that was prevalent in UK. Actually, if we go into the indigenous history of India, there is no such as land tenure. We own lands, and there is no tenant and masters owner relationship. So it's a colonial concept. We first need to learn how to decolonize that land tenure system. So in decolonizing the term, we need to see two aspects when the legislature forms policies. The first aspect is on the part of the doctrine of eminent domain or the Rickelian doctrine. And the second aspect is the social aspects. But we are an independent nation, and therefore we require the eminent domain very much. And without eminent domain, we cannot go ahead. But at the same time, the diversity of social fabric is very important to take into consideration while applying the eminent domain. Looking at that, we have the 2013 new acquisition policies, and it's an experimental stage. There are multiple litigations in the Supreme Court. Some landmark judgments has been given by the Supreme Court, even on the new enactment. But however, that enactment, even though it was met with a concept to decolonize the land tenure system, the lower sections of the society still, we cannot say a much improvement in the rights, the equitable ownership land rights. So we need to first focus on it. If we look into some cases of other nations, or neighboring nations, maybe like Philippines, right? Or Philippines, they have a Ricalian doctrine. We don't have an imminent, and therefore they have a much stronger principle, and that's how you can say Philippines, you can say the state ownership. The whole land is owned by ownership. There's no concept of private ownership. And that's how lower sections are being deprived, their lands are being taken by the state forcefully, even though they own land before the French and the Americans. And now if we go into the Australia, right, it's an advanced continent, we have the Native Title Act. And that came out of a litigation of the Mapu versus the Queensland judgment. It's a very lengthy judgment where the High Court of Australia has discussed right from the colonial annexation till today. And out of that judgment, it has not been reflected till today in any of the judgments in the Supreme Court. Maybe we are yet to file a BIL soon. Traditional land rights cannot be extinguished by the state annexation. It continues to do so even in the absence of any records. So that's the variance between the Philippines and Australia. Now, if you go to the Latin American nations, let me take an example of a nation like Belize, right? They have a constitutional right similar with the Indian Article 300A. You can say the Mayan Litters case, one of the landmark judgments of the Belize Supreme Court. Now that was completely in favor of the indigenous land rights issues. So we will see a variety of nations right from our neighbors, the Philippines, then comes Australia, the Mapu's case, then the Native Title Acts, then we have the Belize nations. Now coming to India, if you compare India and those nations, the new Land Acquisition Act, even though to some extent it is similar, we can compare with it because it is based on human and equitable ownership rights by providing some compensation. Now the question is the compensation in the court of law, right? And when there is a conflict of that compensation and eminent domain, the question comes your fundamental right or of equity under Article 14 and also Article 300A. Up to what extent we can enforce 300A, right? So it is a pure domain before the judiciary and how you argue before the court. So that's how we have to say that we have to have some legal reforms. Maybe we will require maybe in the next 20 years, another reforms. That's how I will conclude it.
Thank you very much for that. Actually, on the point of disputes, I'm going to come back to you, Pradeep, because Sir has been with an additional commissioner of revisional courts in with the administration in Odisha. Before that, I just want to go to one of our online panelists, Anindya. So Anindya Banerjee is a lawyer and has had decades of experience at HDFC as a national legal head for retail lending. And as a practitioner, Anindya, what do you think are the primary barriers today that are preventing retail borrowers or even smallholder farmers, marginalized communities from accessing credit, formal credit using land as collateral? And if you could lace it with examples from your your practice, that would be great.
Thank you, and thank you to everyone here. I have been with the SDFC group for.
Sorry, 1 second,
Am I
Anindya, we
audible?
can't hear you. Can we fix the volume
Am I
problem,
audible?
please?
Hello.
We're not able
Let
to
me know.
hear our line panelists.
Benzo, I think we are able to hear you, but I think on their end.
Oh, okay. Am I audible
Yeah,
to the
they're
rest
not
of you as
audible.
well? Okay. So I think it's something at their end.
Okay, so while we fix that, then I'll just move to one of our in-person panelists. So Pradeep sir, could you tell me a little bit about the kind of land disputes that typically arise that you see out of these complications in the legal framework before revisional courts today?
Thank you, Jaya. So we hold the revision courts. Revision courts are basically the apex court in Odisha land record regime. Every state has they have a revisional hierarchy in the revenue laws. For example, Tahsildar, then sub-collector, then collector, then RTC or revisional commission. The highest is member board of review. In Rajasthan, we have in Uttar Pradesh, in many states, the highest authority to settle all land records disputes. We have civil laws where you can declare your right title interest or even succession. Any portions of land, civil laws can do, but it's very costly. You have to deposit the cost of the total cost of the land, some portion. Then even after decree order is passed, you have to execute the decree. You cannot get the judgment and ask that to correct the land record. But since the land records are prepared by revenue department, government settlement department, they have their own hierarchy how to settle their land records. It's very fast. So since we are bureaucrats, we hold as a quasi-judicial power. So we summon similarly judicial process we hear. So government they put their lawyer, so people there settle them, put their through lawyer. It's a very costly process, but we are making it faster. So land records are like this. For example, I purchased land from Kia, but even after settlement, these land records still continue to be recorded in her name. Or there is also problem in extent and size of land. Or she purchased homestead land, but it is recorded in the agricultural land. Or she purchased the land from deity without permission, again the land went back to deity. Or she purchased some jungle land, or she purchased the land through showing the roads, passage, but in this final settlement there is a problem is she doesn't have access to loan. Or she sold the land, there is a transfer property act is there, sorry, there. You cannot sell the land in joint holding without the consent of a co-sharer. But at the same time, Supreme Court and High Court always given what happened. There is no bargain partition, no court dispute, no court directed partition. Can't I sell the land? I'm suffering from cancer. I want to sell my daughter. So notional 5 acres, 5 brother, 1 acre he can maximum sell. But he will sell 3 or 4 acres land. They're depriving poor brother. So that is again disproportionate share. Notional share. We also sometimes step into the shoes of a civil type of dispute. Then many people sell the land, depriving or submitting false certificate of their daughters or their sisters. So the depriving the rights of women. So many type of land disputes which also can be addressed civil court, can be addressed because all in the name of records, there are errors in there. So illegal records, wrongful records, or fraudulent records, or land grabbing, systematic way in connivance collaboration with revenue authority, the land grabbing, or fraud by suppressing, deceiving, or misleading the revenue authority, manipulating records. So land fraud we also do. So our ultimate objective is to clear the land records of a dispute, so you pave the way for the dispute-free landless and more augmentation of land are taking place. Again, we also create. So we are not empowered to do partition of the land. We also do some kind of via media. You do since he is possessing prime upper title with coupled with title possession in possessing for registered sale deed. Also let him to possess to the extent of a boundary as prepared by craftsman. So we do different type of land. It is very dynamic. So very you can't imagine what kind of dispute it will come. So land records are changing.
No, that's an interesting perspective because I think that's just a direct outcome and some of the costs of our complicated land law system today. Just talking about estimating the real costs, is Anindya up? Okay. Anindya, can you just try again, please?
Yeah, sure. Any better?
We can
Hello?
hear you. It's very soft. Can we please fix the sound issue now? Sorry, can
Any
you
better?
try again,
I'll
Anindya?
just sure. Let me know if it's audible enough and we can start. If not,
Can we put a microphone to the speaker, perhaps? That's one way to think about it.
Anindya, just try
yeah,
once
sure.
again.
Let me know. if this is any better, and I'll try to give it a shot. If I'm audible, just maybe somebody can wave and we can get going. No, doesn't work. I understand that amongst the panelists, I think I'm audible, but to the audience there, I may not be audible.
Yeah, we can't hear you. Just give us.
Sure, take your time.
Anindya, I'll just give you a WhatsApp call. And if
Okay.
you could speak on that as well with your video on.
All right, hang on. Yeah, okay. Hello? Hello?
Can you hear us? Yeah, please unmute and speak. Yes.
Yeah, I'm speaking. Let me know if I'm audible or not. Am I audible?
Anindya, just
Sorry, to our online panelists, I think there's some technical issues happening here at Flame. Just they're trying to sort it out. So we'll get back to you in a bit. This is echoing. Is there an echo now? Okay. Moving on to Manoranjan then. You told us a little bit about your findings. Can you tell us about some of the human interest stories, really briefly, that will just highlight this problem dichotomy between laws and actually what is happening on ground, and how there is a disconnect perhaps between what is happening on ground and what the law really says?
Thank you. Actually, what I felt while working in Kandulguda, laws is different things, and what's happening in reality is different. The villagers, I mean, they already told you, the villagers can't read the laws. I mean, the language is the biggest barrier for the people, and also it's very complex to understand. For me as a lawyer, I also struggle a lot because to collect the Yadasta copy, to know the history of the land, it's very difficult. It's not, friendly. I mean, it's very difficult for the people, for the villagers. I mean, for him, I think for them, it's like a heaven thing. So this is very, although we have laws, we have, whatever the protocols or the framework by, the government has been provided, but it's not accessible for the people like Kandulguda village.
Yeah. I'll just add something to my learned friend over here. So we need to understand two things when we talk about laws in this topic. Property law is different and land reforms is different. What we are talking today is reforms, land reforms, not property law. So let's make a distinction on that and let's go ahead. Thank you.
So that's interesting. But just a second. Kshitij, can we just try with you, please? Could you just say something?
Yeah, are you able to hear me okay?
Okay, well, sorry, Kshitij, we can't hear you either. Just give us a minute while we try and figure that out. No, so, just while we wait for them, one of the things that we see on ground, and Arjun, perhaps from your field work, you can tell us a little bit about it, is that, the very same laws or laws that were brought in through reform, which were protectionist in nature, right, are having unintended consequences on the ground. So, for example, some of the field work we did in Maharashtra on agricultural land leasing, where we spoke to owners of land, they rather leave their land fallow and not give it out on lease because they're really afraid that they won't get it back, or they'll have to jump through a lot of loops to get it back, and the cost of getting it back is really high. So they'd rather leave it fallow than give it out for leasing. Similarly, and that's what I was hoping to get Anindya's, view on, which is that when we think about lending, you're restricting access to finance by certain communities because of the way the law is. Lenders, it just doesn't make sense for them to lend. They can't, they don't have recourse to the land at the end of the day. Um, I was just interested in what Manoranjan was saying, which was that, you have these informal lenders who are giving loans to tribal people within the land and charging a very high interest rate. And I wonder if some of that is because of this gap in the lending framework that that the laws have really caused. But maybe we can just hope to get Anindya's opinion at some point in time during this panel on that. But yeah, we can just move on to Pradeep sir. In terms of, if we were to think about how land reform is to be shaped going forward, what do you think in terms of the political economy, the key challenges will be? Do you think it'll be simple to move from what we're doing now to something else? Because we have seen some uptake from states. So we have seen, for example, Maharashtra pick up a model land leasing law. It's not impossible, but what do you think the key barriers will be?
These days, see, I had written a book that from land reform to land titling, says published. Problem is no longer we revenue bureaucrats in India are worried busy with the ceiling, abolition of intermediaries, or the consultation of holding. This, all these are gone. So new questions of land reform, for example, Tahsildars across India, they're pitching conversion of land, or ensuring gender right, or ensuring the Forest Right Act. So some rights based, even street vendors also, they are allowing no longer demolition of their everyday demolition, bulldozing their houses, just shops on the roadside, right to street vendors. New dimensions are coming. The role of the state for a redistributive measure of intervention measure is gone forever. So now, at the same time, the pressure of Naxal, Jami, Jala, Jungle, or the growing landlessness, homesteadness, are issues are there. It is a contradiction. You don't know which way the state will respond. But right up now, the state's approach to redistributive measure is gone. So it cannot play. But same time, as I told, gender issue, forest right, tenancy, restriction of land use on sustainability ground. Soldiers are all busy and crores of rupees being earned through land use conversion fee from agriculture or a fertile land to homestead. Builders are doing massive business. Where there is road, massive apartments are coming. All land use changes. Then changing all these issues are again. This most important issue is parcelization of land because every family is breaking down small parcelization, partition of the land. So new dimensions are thrusting the revenue administration in India. So the interventionist approach is gone. Now the state is playing role to facilitate the market land. For example, tenancy laws, liberalizing tenancy. I am your tenant. I got land informally, but you are worried that moment I ask you to please sign so that I will mortgage your land for 2-3 years to get a loan or on the insurance. You'll throw me out. If I'm Surika's person, you are landed person, you will never sign the agreement so that I will get this 2-year, 3-year agricultural loan or insurance because you know very difficult. You are absent landlord, you are staying in Mumbai. I say I am the actual owner, you are the legal owner of the land. So land leasing will never work. We have tried kind of a lack of trust, unequal asymmetric power relationship, and also the growing fear that moment you do some kind of agreement. So government of India or Odisha is trying to change this doctrine of this law of possession not to adverse possession. For example, that will not work. Even I occupy your land 20, 30 years, 16, I will not get the land ownership. But still I am worried. Still you are worried you will never allow me to get your land mortgage for agricultural loans, even 1 year, 2 years. Even that doesn't actually right property. Because unequal historical relationship there. You will be out.
Yeah, no, thank you for that. Is it fixed? Gosh, okay, Anindya, sorry, we try again, please.
Sure. Let me know if this is any better. Is it? I mean,
Sure. So
No.
Anindya, it is a lot better.
Okay,
Um,
all right. Thank
yeah,
you.
Great.
So
Okay,
let's try to give it a shot.
Yeah, quick question on the key barriers preventing retail and smallholders from accessing formal lending using land as collateral.
I think Manoranjan really answered that when he said that the record of rights was saying something, but the actual land did not really exist. That is, I mean, that really is the epitome of the problem that we have in front of us. See, any institution is again putting money off the general public. We have to be mindful of that. So typically, when lenders come into the picture and try to give money, they are looking at securing the loan. They are looking at various kind of securities. More often than not, it is the land in question, and that land is generally looked at by either the sale deed or the special survey of the record or the record of rights. Unfortunately, these have a traditional thing where largely the interest was always to record the revenue that the land is deriving, and who is getting the revenue. As a result of that legacy, the ownership that was reflected in these records were never they were always presumptive. They were never absolute in nature. As a result, there were a variety of things that lenders would typically depend upon. But unfortunately, while the country moved on from an agrarian economy to a different thing, the laws possibly did not, cope up. So typically, when an area, say in Chhatarpur in Delhi, which is now converted completely, and if you want to take up a loan, you will necessarily find lenders asking you to get permissions which possibly are not required anymore because the inherent character of land has changed. If you look at the dispute of Shaberi village, now all said and done, we were fighting for the rights of the landholders, but the fact is that there was 7 foot of concrete there. Now, while the ground, the factual matrix has changed, the legal situation, although you have very good laws, the problem at the ground level is that there's a lack of certainty. And eventually, although you may have lenders who may want to give away the loan, but the fact is that at the point of enforcement, there are a lot of issues which creep up. There could be permissions which are not taken. There could be stamp duty which is suddenly asked for, or simply sitter. There could be a section 31 of SARFAESI standing on your way saying that this is agrarian land, you really can't help it. Whereas the purpose of the land, as I say, land has always been, in the sense, a utility in the hands of the landowner. Now, when these laws were laid down, India was agrarian, so there was a reason to protect these land tenures. There was a reason to see to it that people were not getting away of the land for whatever be the reason. Today, now the same landowner wants to use. I was doing a project in Ranchi, bang across the stadium. It is impacted by the Chota Nagpur Tenancy Act. Now, the CNTA has a set of restrictions which possibly are no longer applicable in that area, but nonetheless, the landowner cannot really maximize his revenue from that land. The character of revenue today is very different from what it used to be when this law was possibly enshrined. Unfortunately, we have not been able to keep ourselves up to speed. The same problem is there under the UPZLRA, where Section 143 permission is required, but you have high-tech townships, which are all over UP, 1,500 acres, but you're again stuck with the local level issue. Now, a lender would want to have a degree of certainty. In the absence of certainty, what happens is that the cost of the loan goes up. If there's a higher risk, then correspondingly the coupon rate goes up. If the coupon rate goes up, it really doesn't make sense for anyone. As a result of which, it's like a cyclical problem that you can't get credit and it gets expensive. So that's in a very short way, the large. That's what's been my experience dealing with credit giving to land.
Yeah, thank you for that, Anindya. Actually, what's coming out is a data problem, right? Kshitij, that's where you come in. Can you shed some light on the complications in data collection, preservation, perhaps this complicated set of laws presents, and what challenges that actually poses for both administration, for lenders, owners themselves?
Yeah, thanks, Dia. I hope you're able to hear me okay.
Yes, loud and clear now. Thanks.
Okay, great. Yeah, hi everyone. Thanks for having us be part of this, and apologies couldn't be there in person. So I think in terms of the data side, so what we do is we work with different lenders on the due diligence when it comes to land and property. And I think here I would just make one distinction, which is I think quite important. So agricultural land versus non-agricultural land, right? So most people in India do live on non-agricultural land. And I think there a lot of disputes, a lot of issues come up. And so I would say that even the most of the cases that we look at are generally for transactions or credit against non-agricultural land. In terms of the data challenge, I would say that the main issue is the accuracy of the records. Anindya mentioned this. I think we were other panelists also mentioned this. In terms of how updated they are when it comes to the record of rights and the textual records, in terms of when the last survey or resurvey exercise was done, in terms of the cadastral records, in terms of the information contained, whether it's complete, it is referring to that exact either parcel or property. Then in terms of the names of the transacting parties, if everyone's interests have been recorded, if there are inheritances or subdivisions, or there are any kind of for instance someone has died that updated the will and the kind of rights that have been allocated to the other children of the individual, whether they have been recorded or not, so on and so forth, right? So I think the accuracy of the information, how updated it is, whether it's accessible, whether it's in a language that can be actually interpreted easily and utilized by various transacting parties and other actors for that. I think that would be the bigger challenge when it comes to the data. And here we see a huge variation across states. None is a state subject. And it is really something that I think does vary quite substantially in terms of the recording practices, historical ways of recording land, how the records were kept, how much digitization has happened, how much of the accessibility of that information has been made public. Here we see that southern western states have generally done better. It's something that also does evolve quite fast. And, we're hopeful that, this also then starts becoming more accessible and transparent across the country. Here, a multitude of agencies are also involved. So it's not just the state government agencies, but it's also the courts, for instance, to identify disputes, against individual land parcels or, properties built on it. So there we need to have some accessibility of the records from the judiciary as well. So I'm happy to discuss further, but I think there's more panelists, so giving it back to you.
So thanks, Kshitij. Just talking about state variation, Dr. Malakoushi, I'd like to just ask, today we know little about the narratives and the debates that, emanate from the historical conceptions in the Northeast, for example, and how those are different from other regions in India. Could you just very briefly touch upon, some kind of a comparison or some kind of comparative thinking on, different regions in India?
Well, on the local laws, there are variants because of the seventh schedule to the Constitution. But when it comes to the concept of eminent domain, all laws are equal, and that has been upheld by the Supreme Court recently in one of the judgments of the state of Mizoram versus an individual. The Supreme Court says that 371G will not stand in the way of land acquisition for public purposes and national interest, because all central laws are equally applicable. Now that's one judgment on the one hand by the Supreme Court. Another judgment recently in July this year by the Supreme Court Steel Authority and the Mines Area Development case, where the Supreme Court has in upholding the Theresa Manius Jacobs case has laid down that royalty is not a tax. And that's a very good judgment to me, in fact, personally. And that's how I see that when it comes to national entries, I do not see any difference. The Constitution is the supreme, and that will remain the supreme, irrespective of any special provisions. But obviously, we have some other local laws like the Chudanak Ordinance Act, the Sandal um, Paraganse Act, and various other laws in the northeastern states which give some certain autonomy. But now the laws are changing. There are some provisions even in the northeastern states where the concept of which is laid on in the Sandal Act and the Chudanak Ordinance Act has been borrowed in the states like Nagaland, Mizoram, I think in Manipur as well. But I think that is creating a social and a political problem because of the recent land reforms development, which provides some kind of a freedom, a policy and a legal freedom to private entities to come and operate. In other words, they have a right to mortgage land. And that's how that is disturbing a little bit, but I think it is a policy of the government to make a uniform law, both in the special status areas, the fifth schedule areas, and the sixth schedule areas as well. So let's see how socially people will accept. Well, we have recently seen the Manipur crisis, which is to some extent a contribution of the new Manipur land reforms laws. But we have to wait and watch and to put in some good laws, some good policies. Obviously, there will be resentment, but once the people get adapted, I think we have the formal laws that will prevail ultimately. But we should not forget the indigenous rights as well, because that are protected not only by the Constitution of India, but as well by various international laws. So we are in a transition stage, we are in an experimental stage. And so let's be patient, let's hope. That's it I can say. Thanks.
Thank you. Just two questions, one to Anindya and one to Kshitij. Anindya, are there any innovations by, say, private sector lenders to bridge some of these challenges that you see in lending, in this environment of just this complicated operating space that have created? In terms of, I know you said that you'll factor in the risk to your screening as well as enforcement, and that cost is pushed down to the borrower at the end of the day. But are there any innovations that you think as private lenders one could, do or put forth to help bridge some of this, what's clearly a gap in, say, supply to some degree?
So yeah, there is a lot of activity you see that various lenders are doing, not only the large ones, but even the smaller ones, which are closer to people at that level. A lot of activity around satellite imaging, a lot of help from the new fintechs who are working in this space, like my co-panelist Kshitij. There are various such platforms who are equipping lenders and trying to give better data so that the lenders can underwrite these loans in a better way and they make sense to the end user in a cost-friendly manner. Thankfully, a lot of states have also digitized the records. But while we put a lot of emphasis on digitization, the fact remains that you're only digitizing what you have. And that gap is unfortunately yet to be closed. So it's between the record of rights, the spatial land records, and the transaction documents. Unfortunately, the transaction document doesn't guarantee title, so you really can't depend on any one. You have to have a culmination of all three, which is where a lot of these fintechs and legal tech platforms are coming in and joining hands with a lot of lenders. Not only while I was in the SDFC group, we had partnered with quite a few such platforms across the country. Some are strong in the southern states, some are strong in the western states, some in the north. And as a result, that has really significantly helped the underwriting process. Maharashtra came up with a circular that you shouldn't get onto the CIBIL records, but I think largely all lenders were going to the CIBIL records. But the fact is that you have to rely on other parameters also, that how is this one individual conducting in other spheres of life vis-a-vis a repayment pattern and standard. You have cyclical crop patterns, and typically lenders don't understand anything which is not a regular source of income, but only cyclical in nature. But largely lenders are establishing and getting people who understand this kind of lending in a different manner as against the traditional approach towards lending. So there's a lot of activity happening, a lot of hand-holding with things which were not even thought of previously. Even 5 years ago, we were not working with people on legal tech platforms, but today, yeah, a lot of these partnerships are engaged.
Thanks, Anindya. So, Kshitij, just one last question to you, which is, a theme that's coming up is community-generated data, using more participatory processes, having perhaps the private sector come in and aid government in generating some of this data, safekeeping of this data, and so on. Do you think there's a role for this in India, or do you think this is still something that should be within the sphere of the state?
Yeah, thanks, Sia. So I think we'll have to be very careful when we talk about community-generated data. I think there is certainly a role to some extent, and it's already being utilized. You could say, for instance, with like in the Samvitva scheme, I mean, there is a process after the drone mapping is done. Well, first there's the Chuna drawing, and then the drone mapping. And then there is a local dispute resolution, or at least coming up with the sort of potential issues that could be there as a community participated, the sabhas that are held. So there is a role for that, for sure. But I think the challenge here is that we want to make sure that, if you cannot crowdsource disputes on property, for instance, that's something there has to be a barrier, to be able to register a legitimate dispute on a property, right, through the official mechanism, because otherwise then you can allow local powerful intermediaries to come and start putting interest in different types of land parcels, properties, and disenfranchising the genuine, rights holders. Right. So there is a huge, I think that's one big concern that is there. And then the second is that if we allow such a process, we want to make sure that it may it may appear as if that we are resolving potential issues that may come up, but in reality, we are just passing the buck down to the courts at a later stage to resolve disputes. So over time, what it does is it ends up actually increasing the overall level of disputes later on, because someone can come and claim that they had, some kind of document, maybe a genuine, maybe it's fake, and register a claim. And so it's up to then the courts to then resolve. As you know, and they were saying, we have a presumptive titling system in India. So it's up to the courts really to resolve later on, even if a community-based process was followed, in the first, stage to kind of flag potential issues. So that's, I think, one challenge. Ultimately, constitutionally, it is by law, it is the role of the state governments. They have the authority and the responsibility to maintain, to adjudicate transfers of property, to maintain the records, to make sure that those rights, the transfers are sort of documented. They collect hefty stamp duties as a result of it, and in fact, to some extent, maybe that also creates additional problems in terms of, for instance, the true price discovery. Right? I mean, there's a very strong incentive to not declare the true value of the land and the property, and that leads to further information asymmetry. So I would say that one reform there is to reduce the dependency of state governments on transaction, taxes, right? When it comes to transferring, land, property, any kinds of issues that are there. So what Anindya was talking about with, different lenders, for instance, we see this as a big, challenge in different states where lenders do have to pay a lot, or the borrowers need to pay a lot to register, even equitable, mortgages. So, depositing title documents, they have to pay sometimes a stamp duty, and other times they have to pay, honestly, bribes for, to the sub-registrars, and the borrowers are doing this in different, states to be able to just register those documents, to deposit those with different lenders, right? So there is a gatekeeping effort that is, been there with the, sort of established state, kind of entities that needs to be, looked into across different states. Again, here, we see the southern and western states have made more, strides. The states we see are still lagging behind. For instance, Haryana, Rajasthan, the big states where there's a lot of gatekeeping that's still going on and leading to all kinds of costs and other issues to, accessing this information. And ultimately, where you have limited access is where potential issues, corruption, lack of credit, higher cost of transactions, and potential disputes also thrive. So yeah, I would say that's my, so yeah.
Yeah, no, thank you for that. And I think then that gap is then closed by the informal lending sector, which comes with its own challenges. But thank you very much. We have overshot our time. Apologies to the audience and to our lists online for all the technical issues, but I'm glad we got to hear from you all just a little at least. And thanks, Nimai, for joining us all the way from the US. It's the middle of the night, I know for you, but thank you very much for being here. Thanks, everybody. We'll just close the session now. Do you have any questions? If there are any audience questions, we can take a couple now.
Myself, Madhu. I am from Government of Andhra Pradesh, working as a revenue inspector. Sir, this is a nice session. Actually, I just want to share something here. Right of ownership. Mark my word, I am not talking about titling. Right of ownership, because title should decided by the civil courts until the land titling act may come into force. Here, why the disputes are happening in execution? Because owner is one person. In the position, another person is doing cultivation. But as per ROR Act, the person should be in position, and that person having some right of document. And that document and that right should be recorded by the revenue officials. When these three is having, that person should be having a right of ownership. Until then, it would be a dispute only, because we done resurvey work, and at that time we found like owner is another person, and what we have a record-based record. That record is another name, and another person is on position. When survey numbers is also differ due to mistaken of that one, and that is from ROR. And as Sir said, Land Acquisition Act. It's in 2013 Land Acquisition Act have given so many provisions to the public who have a right ownership, and because without doing that, no, it cannot be developed. Because of that act implement, some provisions are there. Chapter 2 and 3 is exemption for social impact assessment. That is only few development projects. Apart from that, this social impact assessment is must. Is it?
Categories, right, for compensation and the livelihood. There are categories. And if you fall within that category, you will be entitled. If you don't fall within it, then you have to go for a writ. That's the only option left. As simple as that. Yes, I agree. Hmm. See, that's the conflict where we have to see. That's the conflict. I agree there's a conflict when it comes to your whether it's acquisition, full acquisition, or whether it's a lease. Obviously, there are environmental impacts, right? And which may lead to rehabilitation of the indigenous people over there or some other people. But we have to see a balance between development and environmental impact. And that's why we have the environmental impact assessment. That's purely an administrative affair. Now, if you have an administrative problem, you deal with an administrative way. And that procedure, see, I agree to it when it comes to when it comes to sovereign interest, my stand. When it comes to sovereign interest, we should not think too much whether there is a social impact or whether there is an environmental impact. It is in the national interest and it is for national security. And if that is so, we go ahead. But if it doesn't fall within the national interest or the national security or for any public purpose, then you have a fundamental right. So that you need to distinguish first. See, some compensation is there. You are not satisfied it, and that's why you go for a writ. Simple as that. So that's a lengthy litigation process, and there is no shortcut. There is no shortcut. I'm sorry. There is no shortcut. There is no shortcut unless the chief minister is your elder brother.
One small anecdote on this. We had also done a survey in Uttar Pradesh, close to where the Jawar airport project is happening. And over there, there are lots of land categories which determine what land ceiling limits you have. Or the highest quality land, that category land was selling at a lower price than much lower quality land, because that low quality land could be acquired. So land acquisition is not always a bad thing. In fact, the compensation that a lot of farmers get is higher than they would get in the market. So this quote unquote low quality agricultural land was selling at a higher price because there was a much higher chance of land acquisition happening to that land.
So, yeah. Yeah. No, and just one more thing. I think all of this is contingent on circle rates, right? Set by the government. That process is questionable today. We don't know how that happens. There's a lot of opacity when it comes to that. We don't know what, good data they're relying on to set those rates. And I wouldn't be surprised if market rates were not changed, where they're more likely to acquire land, where government is more likely to acquire land because that land prices will be relatively lower and therefore less compensation is paid. Okay, we'll just wrap up this debate. Thank you very much. Yes, there's a lot of contentious things going on here, but thank you very much, everybody, and thank you for joining online. We'll see you. Bye-bye.